We have what we think is a neat little program this morning to review the history of our work and really the history of the children's rights movement. We don't go back to prehistoric times, but we go back a little bit, as you'll see. We've organized chronologies around 4 buckets of ideas that you'll see emerge. The first of those, and there's my clicker, good. And the first of those is lawyering for children, we'll get to in a minute. You'll see this wonderful graphic presentation that was created for us by Julie Roos of the Cooley firm. Thank you, Julie. I think you're going to be wowed by it. It's quite cool. We also want to point out that histories are told by storytellers, and the story is always that of the storyteller. There's biases all about, implicit and explicit. And we hope that you will forgive us for any errors, omissions that you find in our storytelling. Just over the past 48 hours, it dawned on me that we had a couple of errors, kind of omissions that we're telling. The one you'll see there is no 1982 event for Santosky versus Kramer, right, which folks may recall is the kind of legendary case that created the standard in termination of parental rights cases for clear and convincing evidence. Now, how'd that happen? Well, I'm a child welfare children's lawyer. That's a parent's case. I don't think it's Santosky. It just doesn't come up, right? So with due apologies to Marty Guggenheim, Marty can write his own story. The one you'll hear is the story of 2 old white Italian guys, okay? So, right?
Should I start?
We begin.
I was fortunate enough to pull Galt, and there shouldn't be anyone in this room who doesn't know about Jerry Galt. So I'm not going to go through the whole Galt story. What I'm going to do is aggrandize to some extent, in 1965, the appointment of Abe Fortas to the court. And Abe Fortas took the mantle of deciding, I'm going to bring parens patriae to the end. I'm going to put due process and the 14th Amendment into the juvenile court. Just think of it. I think of all the time if Abe, what happened?
You keep talking.
If Abe Fortas had become Chief Justice, as Lyndon Johnson had wanted to, and we would have been perhaps to have some pleasure in having a Jeff Sessions and Abe Fortas debate at some point. So I do think Galt brought due process to the court. It changed the way the court was to function.
You'll see in this screen just a depiction of the approach we're taking in addition to the great characters. We intend this to kind of be the wallpaper of the room. We're only going to talk about some of the items on the screen. As you can see, Tony just talked about Galt. There are, throughout the slideshow, other signature events, we think. Again, we ask your pardon for the errors and omissions. One on this moment in time that we talked about last night was Marsha Lowry's work in essentially creating class action impact litigation on behalf of kids in the first case of the Wilder versus Bernstein famous case that was founded in 1973. And we go that way with a clicker?
You got it.
Good. So we all come together because of this event that happened somewhere between 1989 and 1993 that we're calling the creation of the Children's Rights Litigation Committee in 1996, or so on, right? In point of fact, and Mike Tiger is with us, and Bernadine is with us, but we come together because of the visionary work of those 2 tremendous leaders, along with the third, Louise Lamothe, who had this idea that the ABA can get behind children and get behind the law of children and can advance the practice of children on behalf of children, including pro bono work and all sorts of other stuff that we have all been unpacking together for so long. So we really celebrate them. Let's give them a hand. The directory?
The Model Act was one thing we worked on in 2011. Actually, it seemed like we worked on it for about 4 or 5 years.
No, you're not on the Model Act. The directory.
You lost me.
The directory.
The pro bono directory, yes. That was the first time that Kathy Krebs and the committee took an opportunity to find out what was out there, what children's law centers were out there, what pro bono programs were out there, what kind of centers were attached to law clinics. And we put together the pro bono directory. It was the first time that was ever done.
With due credit to Nora Quinn, who preceded Margie Gualtieri and Kathy Krebs as staff to this committee. Nora spent a lot of time finding programs. Back in 1993, we couldn't find them. There was no book. There clearly was no internet. And we were really the first to go mining for programs and to put them all together in one place.
Is it in Sanskrit?
The ABA Standards of Practice for Representing Children in Abuse and Neglect Cases and the Fordham Conference, the first national conference on the ethics of representing children, both happened in that space of 96, 97. And this was the first time that people got together to think about the practice of law in a coherent, in a thoughtful, in a principled fashion, and put that stuff on paper. There were law review articles dating from the early 70s, but not much even before that. But in 1996, a team of folks got together to try and draft standards of practice. Eventually, that group split into two kind of sub-working groups, one on abuse and neglect and one on domestic relations custody. And that conversation gave rise to the ethics conference at Fordham that resulted in the production of an impressive work that also doubles as a big doorstop in many of our offices, right?
The Model Act is one of the things on the screen, and the Model Act was something that the committee worked on. It isn't something that the ABA generally gets into, creating a Model Act for states, but it did do one thing we wanted, which was to give each kid the right to counsel. There were arguments, there were debates over whether it should be, a counsel should do the express wishes or whether it was best interest, and how do you represent a newborn. But it was a task that was needed to be done. It took us 3 or 4 years of unbelievable time to put it together, but we put it out.
And then just last year, the work of Don Duquette, retired from the University of Michigan, and a team in creating the QIC Child Rep Project, published their exciting book offering a direction for the training of children's lawyers and for the practice of children's law. The QIC was a federally funded 5-year study, big, using 2 major jurisdictions and studying with control group, really, in a sense, a hard science approach to finding out what worked in children's law. So it's wonderful. The book is available on the ABA website, and it's a good read for folks who want to instruct young lawyers and others about the work. Each of our 4 topics will have in it a bucket of ideas about where we're going.
These are just ideas that we put forth. Your job today is to come up with detail on them, to come up with specifics and also advance them. But obviously the one thing that we shed most is the counsel for all parties in a case. We certainly want expansion of multidisciplinary practice where attorneys can have people who can help them find resources and disposition. And we certainly want to have betterment in the practice of law with attorneys. They need better training. They need better support. They need the impetus of passion sometimes.
I wanted to give a nod to the American Law Institute's work on the restatement of the law, Children and the Law. Folks are maybe familiar with the various restatements of the law. I'm fairly convinced that the restatement on torts is what drove me out of that kind of practice. But the restatement of the law on children is an exciting new work. Some folks in the room, and fully it feels like 100 people involved in a working group, are producing this, what I expect will be a fairly massive tome and a very well-reasoned piece, kind of in the classic tradition of the restatements. Our second bucket focuses on kids who are different. There's a wonderful poem that I love that begins and unpacks the phrase, "Here's to the kids who are different." And we're going to look at the tradition of Roper and what preceded Roper in its understanding of how kids were different. And we begin with the notion articulated by Jane Addams, that, in fact, kids should be treated different.
Jane Addams, with her cohort, started Hull House and also urged the creation of the first juvenile court. You guys probably already know all of that, but you didn't know that she was the answer to a Jeopardy question last week. Jane Addams believed that there was immaturity, that children should be treated differently, that they were less culpable, and that they needed that care and guidance. And she carried that forth, not just in children's issues, but she was a suffragette. She was a activist in many fields, and she carried forth, and she's been proven correct 115 years later. Me?
Yes.
We're back to Abe Fortas here, because what we end up with is which one am I on?
Yeah, Tinker and Kent.
We started with Abe Fortas. Abe Fortas did Galt, but before Galt, he did the first case that ever came to a juvenile court, which was Kent. And he injected into our parents' patria system due process, the 14th Amendment and the Bill of Rights. And that, he also did another case. He did Tinker versus Des Moines, which is on the field. And that was actually a First Amendment is not barred at the schoolhouse door, as all schoolhouses seem to decide they want to bar the First Amendment and kids' rights to speak and talk about what they can.
Tony is the first of his kind, an Abe Fortas groupie. All right. I thought we'd talk about leadership in the context of the ABA juvenile justice standards and this event in 2000 at Northwestern. In both events, moments in history, we have to focus on the role of leaders in our community who stepped up to create a new direction. So the juvenile justice standards, I remember Bob Schwartz from the Juvenile Law Center turning me on to those in the 80s as the significant tome, the first time the ABA set about to articulate the direction of practice and really the direction of social work practice. There's even a volume on institutions and the space that should be available to kids in bedrooms, the square footage. It really got down to the granular in a whole bunch of volumes, 12 or 15 volumes. In 2000, Bernadine and others in our community had the tremendous foresight to begin to take on this most important historic work of taking down the juvenile death penalty. Patty Puritz was involved in that conversation around the same time, and we certainly nod to our beloved friend Patty. But leaders got together and said, we can make a difference on the juvenile death penalty. We can change this fundamental and abominable practice. And didn't they go do it?
In 2005, Roper came along. It came along after Atkins. Atkins established that you cannot put a less culpable person, a mentally retarded person, to death. Roper followed that. But as in all death penalty cases, you've got to have a couple of things. You've got to have proportionality, and you've got to have consensus. They first of all had the brain science, trauma science. That was all developing at the time and getting bigger and bigger and more believable to the courts anyways and to the general public. So that was part of it. Atkins helped that case along as far as proportionality goes. But consensus was built differently. Consensus was built state house by state house. What was going on? There were, I think, 20 states that had the death penalty. Had they executed a juvenile, they'd only executed like 5 or 6 over the last 10 or 15 years. So even though the consensus was building slowly, albeit slowly, it was building, and it was done state house by state house and case by case. I would point out only that Roper ended up 72 residents of prisons who were on death row were freed as a result of the Roper case.
In 2005, the Children's Rights Litigation Committee got into the game, teaching the lessons of Roper to a national audience with this teleconference that continues to be available, I'm sure, on the committee's website, and its progeny in Graham, and we'll hear more about as we go. Of course, you have Miller.
Miller. This was a little bit of a leap, and it was a lucky break because Miller moved forward again. It looked at unique circumstances, life without parole. This was, again, consensus was built in that period of time. There were surveys done of state legislatures and surveys done of different law. So this was something that was a little bit of a jump, but a welcome jump. 2,200 inmates who had life without parole, who were juveniles at the time of their sentencing, were now eligible for parole. 2,200.
Going forward, we want to think about how kids are different and how we as lawyers are going to treat that difference. This is your list, I think.
Oh, okay. Where are we going? Well, we want the voice of the child to come out, not only in the courtroom, but across broad public sector. I didn't see it, Angela. Okay. We want that to come out. We want greater diversion to keep kids out of prison. And this is happening, or out of the juvenile justice system. And this is happening as the legislature is increasing jurisdictions across the state. We're now moving, brain science has told us that up to 22, 24 years old, the brain is still developing. If we can get the juvenile court to move towards 18, 19, and 20 years old in keeping jurisdiction, we can relook at that. We want lawyers raising that, as they did with Roper, taking that, not being afraid to go forward on a motion for funds, to get an individual, to get an expert. We want to focus on older youth. This is something that's personal to me now. Many states have expanded their jurisdiction, and the kids now getting older who leave the Department of Children and Families or the state agencies. Those kids are now coming to the adult court. 70% of kids who age out of a state agency custody, 70% end up homeless at some time, and 70% of the boys end up in jail. So we've got to educate the district courts, the superior courts, and the criminal courts about our kids.
Next, we want to look at child protection. Well beyond the traditional notion of child welfare, we know that we as a community have been trying to protect kids, sometimes successfully and sometimes not, for a long time. We begin with the child labor laws, right? Kind of well-intentioned do-gooders trying to make a big difference in New England, right, Tony?
Lawrence.
There you go. And the orphan trains, right? Getting a lot of attention in the current national dialogue of literature and otherwise. Undoubtedly, I haven't read the most recent book, but undoubtedly these were in a sense, our predecessors looking at a way to take care of kids. We now, with the benefit of 100 years of hindsight, can see how, in a sense, wrongheaded that whole reform effort was.
Everyone in this room who does child welfare knows the story of Mary Ellen Wilson. She was an adoptive kid whose parent, in fact, her father was killed in the Civil War. She ended up with an adoptive parent, and the adoptive parent abused her, seriously abused her. But the only way to get Mary Ellen out of that, the Division of Public Charities in New York went to the home, but they had no power to stop the abuse. They saw what was going on. So she enlisted the help of the American Society for the Prevention of Cruelty to Animals, so that the agency that basically at that time, 1874, made efforts to help horses who were being whipped and things, ended up changing that. And Eldridge Gerry, who was famous from gerrymandering, was the attorney who took it to the Supreme Court of New York and was able to get a habeas corpus and get Mary Ellen removed from that home. That was the first time that an agency made an effort to get a child protection. And there later came to be the New York Society for the Prevention of Cruelty to Children was formed at that time.
We've mentioned Jane Addams. The movement gained some traction as well in Washington under the leadership of Teddy Roosevelt in the first White House conferences on children. And in the current day with the foundation of the Children's Bureau at what is now HHS, and Marion Wright Edelman's leadership work in creating a very important program I know was inspirational for me as a young lawyer going to one of her early conferences, hearing her speak and hearing so many others, and it really getting under my skin that I wanted to be in this game.
Bellotti versus Baird, 1979. We put this here because this is a mature minor doctrine case. But it's interesting in that the court, in deciding that, I think it was Powell, looked at a couple of things. It looked at, one, children are vulnerable. Children need help. They don't always make the best decisions. But it also said these are health care issues, and the child should have the right to be present, to have their position and decisions made in these health care issues. So it recognized that children should be part of the decision-making process.
The 1980 Child Welfare Act, the Adoption Assistance and Child Welfare Act, created the federal construct that we're all familiar with of so-called federal financial participation, the reasonable efforts construct, and so many other elements. Another omission, somehow or another, was the 1997 Adoption and Safe Families Act, ASFA. But on reflection, I had the thought that I'm sure at least half the room hates ASFA, so it's okay if we left it out, right? The Steering Committee on the Unmet Legal Needs of Children publishes America's Children at Risk under the leadership of the beloved Leon Higginbotham, who many of us work closely with. Judge Higginbotham had this distinguished practice in civil rights work, and then on the bench in Philadelphia, the federal bench. And I think Bernadine invited him to this work, and it was one of her many, many brilliant moves.
Fostering Connections is sort of a follow-up to the Adoption Assistance Act of 2008. What Fostering Connections looked to was to provide some kind of educational stability. The average kid in foster care goes through about 7 foster homes in 4 or 5 years. Seven foster homes. That basically affects their education. Only 75% of the kids where custody is taken by a court do not return to their same school. And the average foster kid is usually starting school at the minimum about 6 months behind every other kid. So Fostering Connections says that stability must be provided, educational stability. The kid has the right to stay at the school where he initially was enrolled.
Lastly, in terms of, in a sense, problems that the child protection community has been addressing and kind of living in the tension of it, I thought we ought to think about how many times in our work we have thought of family as the problem, in the context of domestic violence, in the context of poor families, in the context of picking a better family, right? There's always been this tension in our work that we have struggled with. It's got to be more than 5 minutes. Angela, we got at least 7. Where we're going, we're looking at quality legal practice. We're looking at greater support. Would that it would be, right? From this mouth to God's ears, greater support from the courts and the legislatures, sense of restorative justice, and a sense that the family is the solution. That really turns it on its head, doesn't it? Our last bucket of ideas turns to the subject of the day. Oh, we missed that really cool slide, Julie. Let's do it again. Just one more time.
There you go. Yep.
This is really cool slide. Where this notion is of children's rights. Is it playing? Oh, damn. There we go. It's okay. We lost that motion. It was this really cool thing. There you go. And you're next.
Okay. Civil rights are human rights. This brings us to a case that everybody in this room knows, Brown versus the Board of Education, 1954. Basically, racial segregation in the public school system violates the 14th Amendment to the Constitution, denying equal protection. What Brown's important for, because it didn't change things in the next 4 years after Brown. There were a number of Browns. But what Brown is important for is it established a foundation, a 2-foot wide foundation all around dealing with civil rights. And following Brown, we had Rosa Parks, just I think a year or so later. Following Rosa Parks, we had the leadership of Martin Luther King. And following that, we had the Voting Rights Act. We had the Civil Rights Act of '64. We had the Fair Housing Act. All of those things came about because of Brown, where the access was there, let's take it and let's move with it.
We come to the Indian Child Welfare Act in 1978. And in 1989, the UN conventions, which I think Tony's going to just mention.
What can you say about the UN convention? It was mentioned in Roper by Justice Kennedy, which I thought was interesting. The UN convention, it was passed by the nations of the world in the fastest amount of time. I think it was 2 or 3 years. Nothing had gone through. Only one country has not signed it. And then President Clinton signed the UN Convention on the Rights of the Child, but it has never been ratified. It's never even been sent to the Senate for ratification. We are the only country in the world. It contains some things that some people in Washington don't like.
The 2006 case, Kohler, took up for the first time in the Supreme Court the rights of LGBT youth. And so we turn to where we're going, because Angela's about to kick us off the stage.
Which is the answer that you have today to answer. You've got to look to where we are going. I have my biases, and I will submit them for the clicker so that everyone gets a look at it. But inequalities still exist. They exist in our school system. They exist because of residential patterns. They exist because of the economics of funding our school systems. But the inequalities between poor kids and rich kids have got to be dealt with in some fashion. Maybe it's school funding. I don't know. That's one thing I'd throw out there for you.
We wanted to highlight that we need the next generation of ideas. We talked about all these times that our predecessors and the folks in this room had some interesting idea, some bold idea, some crazy-ass idea, and then it became law. What will be the next set of ideas, and who will be that next generation of leaders? All of us need to be growing the new leaders in our offices and in our communities, and those of you who think you all are old but are really young, you are the next generation. Lastly, we just want to talk about who we left out.
Stakeholders.
Right?
They're stakeholders.
Huh?
They're all stakeholders.
Well, they are. There's all sorts of young people, communities of people who we left out of this conversation and who we have left out of the movement. Whether it's the Native American children living on the res at tremendously high levels of poverty. Whether we're talking about LGBT youth and in a sense, the new orientations and understandings about gender. And then all the children of the world. When I think about what I want to do next, and I don't know if that'll ever happen to be, I think of all those other places in the world that have so many more kids who are in deep poverty, in deep need, who are looking for a lawyer. I wanted to be in that group. I want to be working with them. Those are the communities we need to be thinking about, because as needy as our kids are, there are tens of millions of kids who are at a much, much higher level of need. They need our help. They need our justice. They need our vision. Thanks very, very much, folks.